Hi guys, I hope you can see us and I hope you can hear us clearly as well. My name is Varsha and I'm from HOMEIS. For some odd reason, my screen name says Darshan Shah, which is one of my team member. He's also here in the session, but you can't see him. He's helped me set up this whole system here for the webinar. Quickly, I want to tell you a few things here about the format of this session. This is going to be a question and answer round. So keep your questions ready, but you're on listen only mode, so you will not be able to speak them out. But there is a question window at the bottom of the window that you have on right side. So please write your questions, which only I can see, and I will share with Rajiv ji, and he will be able to answer them. Now, quickly, a little about Rajiv ji. Rajiv ji is our immigration law expert and has been very kind in hosting these sessions with us. This is the third session that we are hosting with him. He started practicing law in 1984 and he started his own practice in 1994. That operates in all 50 states across the 7 continents with the primary focus on legal immigration. Now let's just begin. I want to just mention one last thing that if there are a lot of attendees, then we would be addressing one question per attendee to begin with. But if we are left with more time at the end, we'll happily address more questions. So Rajiv ji, welcome. And I would love for you to speak about the whole development that happened on H-1B visa recently. Are things looking good for us there?
Yes. Good afternoon, everyone. Pranam Varshaji.
Namaste.
So, lawsuits have become a fact of life under the Trump administration. USCIS has resorted to some very underhanded, sneaky tactics for a while now. And typically, we don't go to courts over these cases because, one, they are expensive, and two, they take too long. However, at some point, there is a point of non-negotiability that it just cannot stand. So iTech Alliance, they filed a lawsuit. They did very well in doing that. And there were many issues of contention there, but I'll summarize the ruling of the court.
Sure.
There are some complex legal issues, not that complex, that our people who are listening in are very smart people. If I had the time, I would explain and you would understand them. But the idea is that before you file a lawsuit, that lawsuit has to be filed within a certain amount of time. If that time has passed, you may not be able to attack government action as fully as you would if you filed within that time. That's called limitation.
Okay.
So one of the issues was how many of these claims are, for example, the 2010 Neufeld memorandum, which is very infamous. Varshaji, you wouldn't have had to encounter that, but people who are doing H-1Bs,
Right.
they know the Neufeld memorandum, which was one of the dumbest pieces of legal writing I've ever seen. It was objectionable on a bunch of grounds. Unfortunately, when a lawsuit was filed against it, in my view, that lawsuit was not well briefed. So the lawsuit was thrown out. The same memorandum in a well-briefed complaint and a summary judgment motion, which is the next step. The court agreed and they said, okay, well, it's 2010 memorandum, it's too old, you can't really challenge it, but you can challenge it as it is being applied to you. So you can't challenge its validity, but you can challenge as it is being applied to you. What does that mean? That means if the government tries to apply the Neufeld memorandum on anyone from now on, they can take it to court saying you can't apply it to me. You may not be able to revoke the memorandum, but you can certainly stop them from applying that to you. What is the big deal about the Neufeld memorandum? I have been arguing with the USCIS for 18 years, 11 years, I guess 2010 is when it came out, that you have it wrong. You have created a new definition of employer-employee relationship, which is exactly not what your regulation says. The regulation says, and I'm paraphrasing it, I may not be exact, anyone who has the power to hire you, fire you, couple of other, or otherwise control you. So there's an or, and or is always disjunctive. You cannot consider or to be conjunctive. You cannot say or means and.
And yes.
That's what this memorandum did. This memorandum said, if you don't have the right to control, I don't care whether you can hire, I don't care whether you can fire. How is that very sneaky? Well, in a model where you are placing employees to work at third-party sites, you may not be able to demonstrate control.
Gotcha.
Okay, so they were destroying the technology industry single-handedly and the consulting industry in general. And the court said, nope, you can't do that. As this is applied, it is not allowed. So in future, guys, cases that are pending to be filed or already decided, you might be able to take advantage of this. Remember, you have 6 years to challenge the government action in courts. Most APA, Administrative Procedures Act, under which we challenge the government usually, they have a limitation of 6 years. So anything that has been done to you incorrectly in the last 6 years, by all means, knock the government's defenses down. They are absolutely out of line. And the court agreed with the plaintiffs. They said, no, you cannot apply the Neufeld memorandum. That was the big thing. On top of that, they also said other things like you cannot require exact itineraries, because they used to say, for 3 years, you have to demonstrate that there's a project. Court said, why? You can't. Nobody can. Nobody can show for sure that you've got a 3-year project. You can do 6 months, you can do 1 year. Who can do 3 years? And in any case, you were accepting the employer's statement for years that we've got a 3-year job for this guy. And if we are not able to place him, we'll pay him. That was good enough yesterday. Why is it not good enough all of a sudden under the Neufeld memorandum? So now, one thing is they can't insist on that employer-employee relationship. Second is they can't insist on itineraries. Third is they can't insist on demonstrating 3 years of projects. And fourth is they can't demonstrate on, they can't insist on having an exact kind of documentation covering all these points. So it has become, I think, a level playing field for the first time in 10 years.
Okay, that's great. Are you in general getting a lot of people who are now coming back to you with such cases? And
I just finalized 2 lawsuits today. We filed 3. Another one we are filing coming week on an L1A denial. We are filing one on an EB1A extraordinary ability denial. We are filing one on delay. We've settled 2 on delay already. So bunch of cases going on.
Okay, great. Sounds good. That was very helpful piece of information, Rajiv ji. Thank you so much. Let's begin with some questions that we have here from our attendees. And before we do that, I just want to say something which is very important, which Rajiv ji taught me in our last session, that if maintaining your anonymity is important to you, then please do so by all means. We will not be able to help you there. So if you want to stay anonymous, you have to do it by yourself in whichever way you can.
Right. I may add a quick disclaimer here. Folks, us talking to you doesn't create an attorney-client relationship. You can't depend upon us as being your lawyers. We're just trying to give you a short piece of advice based upon whatever you tell us, more to guide you, but it's not a full-fledged consultation. We do not represent you. And also remember, tomorrow, if the government decides to subpoena the records of this call, they will not be protected. Varsha will have to comply with the government. So if you want to remain anonymous, most of our people don't have to, but in case you want to, why not?
So yeah, great. So I'm going to touch upon this first question that we have here. And the person says, I have waiver from USCIS. My spouse do not want to change her status. She's on J1, only J2 change status to H1. What are the options for J2 change status, to change the status?
Okay, I think what you're saying is
J2
this.
can change to J1, sorry.
Right. No, I think what you're saying is, and I could be wrong, please correct me. I think what you're saying is that I am the spouse of a J1 holder. So I'm on J2.
Yes.
My wife does not want to get a waiver. Can I get a waiver? The answer is no.
Okay.
The only way you can get a waiver is if you are actually, well, not even a waiver, you could argue that you are, I don't remember exactly what we need to do, but if you were genuinely divorced, not as a fraud upon the government, but if you were genuinely divorced, there might be some options for you. But as long as you're married, she calls the shots. If she decides not to get a waiver, you're stuck with it.
Okay, but I think he's saying that he's on J2 visa and he has a waiver from USCIS?
Cannot. He cannot.
Ah,
That information is incorrect.
okay, so he should better get it checked.
Unless she has obtained a waiver and he's inherited it.
Gotcha. Okay, great. So if you're listening to this question and your answer, if this answer helps you, then that's great. If not, and if you have any other question related to this, please feel free to throw it at us and we'll address it at the end again.
Certainly.
I'm gonna jump to the next question now. Give me 1 second here. I have few questions. My employer is not in a situation to file for H1 due to low budgets of the company, but can he apply for green card instead applying for H1 for me?
I'm assuming that you're not born in a country which is very backed up in visa numbers. For example, India, China, Mexico, all these countries where there are more people than visas, you would be out of luck because applying for a green card is not an immediate remedy. It would take you 11 years, 12 years to get your green card. In the meantime, you cannot stay here just because your green card is pending. If, on the other hand, you were born in a country that's not backed up, to take an example out of Asia, born in Sri Lanka, Bangladesh, Pakistan, these countries are not backed up. So let's say you're on your student visa, chances are good that you'll be able to complete your green card while you still are on your student visa. So the answer is maybe, as long as you're not from a backed up country. And also remember, if they have a low budget, if it is coming from lack of income, that would be a problem for your green card as well. But if on the other hand, the company has sufficient income, they just haven't budgeted for H1Bs, we can understand that. But green cards are expensive. They have to pay for it. That's the law.
Okay, gotcha. Cool. Well, yeah, this person is definitely from India, so I'm assuming your answer helps understand.
One quick point. If you are from India, but you are married to somebody not from India, that gets you an exemption as well. That's called cross-chargeability. And that gets you an exemption from being charged to India. Let's say your wife was born in Kuwait, you can actually be charged to Kuwait and get your green card under the Kuwait quota.
Gotcha. Okay, cool. Well, I hope that helps. Jumping on to the next question. My current STEM OPT expires on July 13th, 2020, and I want to join second master's as a day one CPT, but the classes are starting from May 4th, 2020. Can I change my status as day one CPT before my current STEM OPT expires? And this change of status, will it affect my H1B visa application process if that is selected in the lottery in the month of April 2020? I hope I phrased the question correctly.
I understand it. The illegal opinion of the government is that you cannot have unlimited amount of CPT. It's illegal. It's open to challenge. And if we took it to court, they'll probably lose. What the government did was they had always maintained that you can have unlimited amount of CPT. There was some interrelationship between CPT and OPT, but it was never to the extent that they have now ordered. It's not been, there's no input from us or from people who are student visa holders or from the schools. They just decided you cannot have unlimited CPT. You can have CPT, OPT combined 1 year. So if you have received CPT, OPT combined 1 year at one level, masters, if you do another masters, you won't get any CPT. The funny thing is, nobody knows. The DSOs, and we talked about it the last time also, the DSOs are still designated school officials. They are the school international students office. They are still giving you CPTs.
Right.
But when you go to change status, for example, if you go from F1 to H1, they'll approve your H1, but they'll make you go outside USA, saying, oh, you were out of status. Okay. So the situation is, illegally, USCIS is saying, we have gone back on our interpretation. We will now not allow you to have unlimited CPT. And if you take it, we will make you go outside USA for next visa stamp.
Gotcha.
So you choose.
Okay, cool. So let's move on to the next question now. Okay, so the previous question about the whole change in status of the J2 visa holder, the person is asking, we both have waiver. My wife,
No problem. then there is no problem. Once you have a waiver of your J2, which is coming from the J1, you are just like anybody else. You're like a student visa holder. You can apply for an H1B, go through the lottery, get an H1B. No worries.
So that's his last question. Only J2, like can only J2 apply for it?
Oh yes. Oh yes. Once you get a waiver, you are now immigration law wise divorced from your wife. You can do whatever you want. You're separated from her. You can have an H1. She can continue to have a J1. You can have an F1. She can go on an H1. You can go your separate ways, immigration visa wise.
Okay, gotcha. I hope this clarifies his query. The next question is, my wife is the Indian passport holder. My wife's Indian passport is expiring on May 20th, and I have not received my green card. How should I proceed for her passport?
You have to contact the Indian consulate, and I think they have an expedited procedure. I don't practice on the Indian side, so I don't really know how that works out. But no doubt you would have to contact the Indian consulate in USA, one of the Indian consulates.
Okay, great. Another very interesting question we have here. Generally, few of my friends are receiving RFEs for job duties. What is the reason for this question being raised, even if the person is experienced for many, many years and is also having a letter from the clients?
Okay. So remember, we have Stephen Miller in the White House. When you bring snakes to the White House, you make it a den of snakes. So this policy, this illegal policy, overly obtrusive policy, overly obstructionistic decision making is coming straight from the White House document. USCIS has taken it upon itself to deny as many cases as they can.
Oh, wow.
And they will try to find every excuse. And one of the
Hmm.
excuses is, well, we've looked at your job description. We don't think a degree is needed for this. And more specifically, we don't think the degree that you have is needed for this. Okay. So they look at the job description and they say, well, we need we need to know more about the job description. We don't know whether a degree is required. So that's why you're getting RFEs. And I'm assuming this is in the context of an H1B.
I would believe so too, because I did hear a lot of my friends as well been complaining about the same issue. So the question that this person asked related to OPT and CPT that you answered, he has another question saying, would this change of status will affect my H1B application process if that is selected in lottery in the month of April?
It will only require you to take a trip outside USA, which could be a problem by itself, because the consulate is also working for Steve Miller. They are also creating the same issues that the USCIS is. So you are running the gauntlet twice, basically. First you get scrutinized by USCIS, then you get scrutinized by the consulate. So that's the only downside. Otherwise, no. Being on CPT does not affect your H1B processing.
Okay, gotcha. Okay. So the next question is, after associate degree, are student able to get or apply for H1 visa?
No, not unless they have 6 years of professional experience. So the rule is you must have a 4-year bachelor's degree, or for each year of college you are missing, you must have 3 years of experience. Associates is 2 years. We need 2 more years for bachelor's. Therefore, using the 1 to 3 rule, you must have 6 years of experience.
Okay, so that's the condition that one needs to abide by. Okay. Jumping on to the next question, does the green card gets filed for both wife, who's on H1, and husband who's on H4 together? And does it get priority based on country's birth? If yes, then we will get file based on the country of birth of the wife or husband, since it's going together. Like, who gets the priority basically in terms of their, I guess, origin?
Well, it's not automatic. Both green cards are not automatically together, but they're assumed to be. You can separate. I had a call yesterday from somebody whose wife was abusing him. That's what he said to me, that she beat me up. So I don't want to process her 485, and you don't have to. You can separate her case and just dump it. So can you take advantage of your wife's country of birth or the non-filing spouse's country of birth? Exactly, you can. That's called cross chargeability. Google it, you'll find out more about it.
Okay, great. There is one question, Rajivji, which I hope I phrase correctly. I have come to United States in August 2019 on, is it L551 or I-551? I don't know if this is correct one that I'm reading.
551, I think, is a green card, but I'm not sure. Keep reading.
Yeah, I have still not received the green card.
Yeah. So what has happened is they entered USA on an immigrant visa, but the
Right,
physical green card, which looks like a driver's license, has not been received yet. Okay.
right. And the visa that they came on is valid for 1 year only. So
Okay.
I guess we still have some more time before August 2020 comes, so they should receive it. But if not, then what really happens?
You should have received it within a couple of weeks. If you haven't, there is a way to follow it through. They have a specific form for that. Go to the USCIS website, file that form, try to get information on the follow-up. Secondly, if it comes too close to the end, maybe 2, 3, 4 months, you can always take an appointment in the local office and go get a stamp on your passport that will extend your green card.
Gotcha. Great. Another question, how long does it take to change visa status from F2 to H4 and from H4 to H4 EAD?
Okay. So one of the lawsuits we filed was on an H4 EAD. Government had been sitting on for 18 months. When we filed the lawsuit, in 3 weeks, the case was approved. Okay. So what is the normal time? 8, 9, 10 months. How long can they take? As long as they want.
Oh, wow. Okay. So they just have to like wait and
Wait or sue if it becomes too long, and I hope it doesn't come to that. I don't encourage litigation. This is useless litigation, taking away the court's time. But if you don't have a choice, you don't have a choice. That's why the good Lord made courts.
right, right. Yeah, we don't want to be waiting for the Godot who never arrives.
Exactly.
Okay, I'm gonna jump on to the next question now. I have bachelor's 4-year degree from India, but do not have professional experience. And I asked earlier about the associate degree. Well, can I apply for H1 on my bachelor's of mechanical engineering, which is from India?
As a mechanical engineer, yes. As a mechanical engineering designer, yes. But as a software professional, no. Because it'd be hard for us to prove that your degree is related to software. I mean, in this environment, since that ruling from yesterday, maybe we could win. But normally, if the degree is related to what you will be doing and you have no experience, you should be fine. If you have a 4-year bachelor's degree, no experience, but you're getting a job as a mechanical engineer, you're good. But if
Okay.
you're getting a job as a software developer, even though you have 6 months of self-study, that doesn't mean anything. Unless I can prove that your degree is required for the job that you're doing, I can't get you an H1B.
Gotcha. Okay.
And the 3-to-1 rule goes. So if you have a degree in mechanical engineering and 3 years of experience as a software developer, your degree can then be evaluated as a degree in information systems because you've got 3 years of specialized experience.
Okay. Sounds good. I have another question here. Does the green card gets filed? Oh, I guess we answered this one, right? Both for wife who's an H1 and husband for H4. Okay, great. We've answered that. We actually have answered all the question, but one question just came in again. What if the H1 visa is approved and H4, it's by the same person who asked the H1 and H4 visa question. What if the H1 visa is approved and H4 visa is in process? So can the H4 visa holder travel back to India and again come back to USA?
It's a little bit long answer. Let me see if I can put it together for our people.
Sure.
There are 2 kinds of visas, those that require some action from the USCIS before you can go to the consulate and get a visa stamp, and those where you don't need any action from the USCIS. For example, when you apply for a tourist visa, you don't have to first go to the USCIS and get an approval on the tourist application. You directly go to the consulate, you apply, you get a visa stamp, or you don't. H1 visa is different. You first need an approval from the USCIS, then you go for stamping.
Okay.
L1 visa, intra-company transferee, is the same way. O1, P1, a lot of these visas are like that. First, you need something from the USCIS. Once you get the approval, you go for the visa stamping. The cases of derivatives, which is spouses of all these visa holders, are like a tourist visa. You actually do not need any approval from the government. So you have an approval pending, you leave, all you really need is proof of your spouse's approval to get your derivative visa stamping. So yes, you could leave, go apply for a visa, H4 visa at the consulate, take the evidence of his maintenance of or her maintenance of status and approval, and they should be able to give you an H4.
Okay. Great. Rajiv ji, more or less, we have answered all the questions, but as I said, there are more questions coming in, so I'm gonna just speak out the question that I just read. Can one do masters on H4 visa? And if yes, then what about internship and full-time job after completing the master's program?
H4 gives you no special status to do an internship or a job, unless you have an EAD coupled with it. Okay, EAD is employment authorization documentation. So if you went to school, you can do a master's. I don't see any problem with that. You can go to school on an H4, but you will not have the advantage of things like CPT, OPT, etc. Okay, so it's probably advantageous to convert to F1 so that you can get OPT, CPT after a couple of semesters. Internship is a tricky beast. I've looked into this, and I have actually on my LinkedIn as well as on immigration.com our frequently asked questions, some information on this. Employees can give free work, but employers that are for profit cannot take it.
Oh, so they have to pay you the
I
stipend
was
for your.
surprised. I thought this is a free country. I'm not an expert in labor standards acts, but I looked at Fair Labor Standards Act, and that has very narrow exceptions to taking free work from interns. Those narrow exceptions are generically, either you are a not-for-profit, so NGO type thing, you're fine. You can do internships. If you are a for-profit, you can only do internships, free internships, if they are designed for the employee's benefit. So we have unpaid internships in our offices sometimes when there are young men and women who want to go to law school, and they're just out of law school, they want some experience. We have some very narrowly drawn contracts that say, look, we are giving this to you as education for you. We don't really care whether you do any useful work for us or not. You are bound by confidentiality. You cannot talk about what you learn here outside the office. Confidentiality is binding upon you. But all of this is training for you. We are not doing it because we need your work. So internship has its own problems. But if the employer doesn't mind and the employer says, I don't care, I'll break the law, as long as you are not involved in breaking the law, by all means,
You should be fine.
but you can't do paid internships if you're on H4.
Correct.
Unless you have an employment authorization, you cannot do a paid internship.
Got it. But some people just go out there to build their resume or to get that work experience, to get their foot in the door in US, and a lot of people are okay doing a non-paid internship. But I guess they have to be mindful of what you mentioned, that until the time you're not involved in any illegal act, you should be okay.
Absolutely. It's incumbent upon the employer to pay you. It is not obligatory upon you to get paid.
Gotcha. Great. Next question. Will there be any implications if two different employers file for H-1B for a person under two similar profiles?
Yes and no. First of all, information is incomplete.
Okay.
It will be no problem if it is not a quota case. If you are doing an H-1B transfer for 7 employees at the same time, knock yourselves out. No problem.
Okay.
From an immigration law perspective, if you've signed contracts, you could be sued. But if you have not signed any contracts or made any promises that are legally enforceable, which is a matter of state law, not federal law, and I would not comment on that, you have no obligation to file only one case under immigration. If, on the other hand, it's a quota case, you cannot file H1s through companies that are related. And the definition of relationship here is very loose. So even if you had some amount of interchangeable control, or let's say that 3 companies had the same end client and they were all working for the same end client, same project, and they're all 3 filing for you for that project, that could lead to your being canceled out of the H1B lottery altogether. So to summarize, if it is a non-quota case, go for it. If it is a quota case, make sure they are not related and the projects are not related. If not, you can file as many cases as you like.
Okay, does that really increases the probability of you being selected? It definitely does.
It's like having 1 lottery ticket and having 1,000 lottery tickets.
Yeah.
You have 1,000 times better chance, right?
This is great. Great. So let's move on to the next question. My wife applied for EB1 AI 140 in September of 2019, but still have not received any updates.
When was it applied? I'm sorry, when was it applied?
September of 2019. So it's not been 1 year.
Did she say it was EB? Did he say it was EB1A?
EB1A and then I-140.
Why don't you premium it? That's the easiest thing to do.
Actually, that's what the person asked. Do you suggest for premium process? Which I think answers, you just answered.
Absolutely. Absolutely. Premium it. It's worth the money.
Okay, great. Another question. I guess I'm not eligible for H1 and I'm on F1 and OPT is going on right now. So he's on F1 and the OPT is going on right now, but my visa will expire in December. What would be the other way to stay in US?
It's a very open question, very difficult for me to answer it. If you want to stay, you could try to apply for a tourist status and it takes them 8-9 months to decide, out of which about 6 months you could stay, then you would have to leave. You could go back to school for another degree. But if you're trying to work in the United States, your options are extremely limited. So this is a very open-ended question, difficult to answer in the abstract. I would have to know more about your facts. What are you trying to do? Are you trying to stay and work? Are you trying to go back to school? Work options, H1B is the only clear option.
Okay, gotcha. In fact, Rajivji, since you talked about it, a lot of our members here are asking how to get in touch with you directly. Do you recommend an email address or a phone number we can share with?
Just drop me an email at help@immigration.com.
Okay, perfect. So we're going to share this.
That's my personal email. So it comes directly to me.
Amazing.
Help@immigration.com.
Perfect. That's great. So we will also circulate that information with everybody. But I do see another question here. Conditional visa based on second marriage expires on May 5th, 2020. Separated, husband does not want to apply jointly. My daughter is 22 years old, USCIS approved immigration application. Asked to set up interview. My husband do not want to go through this, who sponsored us. The husband does not want to go through the process, who sponsored as guardian or her immigration petitioner, I believe.
You will need to contact a local lawyer. This case is complicated. It might involve doing some of the work before an immigration judge in deportation. I do not know exactly all the facts of the case. It is not something I can give you a snap decision on. Sit down with a local lawyer wherever you are. The reason I say local lawyer, see, much of the work, our practice is national practice. We work in all 50 states. Every major city in this country, we have a client. But there are advantages, and sometimes we prefer that you get a local lawyer, or we can work with a local lawyer. I won't do this case anyway. This is not that complicated that you need 2 law firms working on it. Just get a local lawyer who's experienced with family-based cases.
Okay.
Sit with them, go over your facts, see what they suggest. By all means, take a second opinion from another lawyer. Make sure you're comfortable with whomever you choose. Your lawyers should be giving you good, complete advice, and they should be trying to save you every dollar that they can.
Great, sounds good. So these were all the questions that came in, Rajiv ji. Guys, if you have any more questions, we still have some time left. Please feel free to write them in the question section and we will answer them for you. Rajiv ji, meanwhile, if you have anything, if you get any frequently asked questions and would like to share with our members, please do so.
I have a couple hundred frequently asked questions that I could go over, but I don't think we have all day on the night. Let's just begin with part of when people sue the government, I
Uh-huh.
want to get back to that. The questions that I got asked just today, I'll deal with them, and maybe that will help people understand how this whole process works.
Mm-hmm.
So the person for whom we are doing an EB1A litigation, extraordinary ability alien, she asked me these very interesting questions. We see these folks are very bright. EB1A is reserved for the top few people, the apex of the profession in any field.
Gotcha.
They're very smart people, and most of them embarrass me because they're so smart and I feel left behind. So she asked me, she says, well, we are in the middle of the litigation and I decide I want to withdraw. And the answer is you can,
Mm-hmm.
but there can be issues. If you are withdrawing in bad faith or trying to play cute with the system, the court can say, hey, you have to pay the government their attorney's fees. A few
Okay.
$1,000s. Okay. Normally, when you file a litigation, if the government has not filed an answer to your complaint, complaint is the first thing you file. Complaint means the beginning of the lawsuit.
Hmm.
In India, we call it plaint. So when you file the complaint, if the government has not answered, you can withdraw anytime you want. It's just a click of a button. But once the government has answered, and I want to withdraw, I'll call the government lawyers and I'll say, guys, I want to withdraw.
Mm-hmm.
Do you have any problem? And why would they have a problem? Most of them will say, yeah, please go ahead.
Yeah.
Unless there's a cross claim and they are claiming something against me, which is almost impossible because it's not an ordinary civil suit.
Right.
So then I have to do a motion. A motion simply means an application to the court saying we want to withdraw. Government has no objection, Your Honor, may we please withdraw. So we can withdraw with the permission of the court, and the permission is almost always granted. Why would the court have any problem?
Yeah.
So first question was, can we withdraw? And the answer is yes, but remember these two things.
Hmm.
Second was, she says, what if I want to file the case again? If I lose the case, can I file again? I said, yes. Because an EB1A can be filed as many times, or most of these cases, even H1B, you lose today, you can file again tomorrow. There's no limit. Government gets paid their filing fees. They are happy to accept your case again. So I said, yes, you can file your case again as many times as you like. The only thing I would recommend is if you have lost in court, make sure you have more evidence.
Gotcha.
Or different evidence.
Of course, yeah.
But that it also depends upon why we lost the case. If we lost the case on the merits, where the judge said, no, you're not extraordinary ability, then we need more evidence. If the judge said, look, I'm sorry, I can't do anything for you. Whatever the government has decided is okay. I can't interfere. You can file with the same evidence again.
Okay.
Because basically, the court hasn't decided. They've just let the government decision stand. That's a different situation.
Right.
Third thing, she says, what if I'm entering USA and they ask me at the airport, do you have any lawsuits pending? I said, they don't. This is not a criminal lawsuit. This is not somebody who's claiming that you committed any crime. This is a civil lawsuit, and you can have 100 of them against the government if you like. None of that is relevant. Okay. Fourth thing, will they target me? No. And one thing I'll tell you, in between there was a time when government behaved like, for the lack of a better expression, sissy kids, where they would throw a tantrum if we sued them. But that's not the normal thing. And plus, if there is a tantrum, we can definitely bring it to the attention of the court and say, Your Honor, they are behaving like little kids. You kick their behinds, and the court normally would, especially in DC. I see and I want to point that out as the next item. I don't know how much time we have. There's so much to educate people about, but just 5-10 minutes I will take on this.
Sure.
You see, in USA, the federal court system is based upon circuits. So, for example, California is 9th Circuit. Midwest is 7th Circuit. DC is DC Circuit. 3rd Circuit, 4th Circuit. There are different circuits. And the way the circuits work is, first, you have the first level of courts. They are called district courts. So the federal court system, lowest court is district court. If you lose a district court, you can take it to the Court of Appeals. That's also called circuit court. So the circuit has district courts, then Court of Appeals, and then finally the Supreme Court of the United States. Normally, when you file a lawsuit, you can file a lawsuit where the events occurred. If your case was denied from California, you can sue in California. Or where you live. If you're living in New York, potentially you could file in New York. Or where the government lives. The government lives in Washington, D.C. So therefore, you can almost always sue in DC. There are some other complications here. They're called venue restrictions. But overall, you can file a lawsuit in any one of these jurisdictions. And sometimes how the courts look at a legal issue can be a problem. I had a case day before yesterday, a lawsuit waiting to happen, and we were assessing whether to file the lawsuit in New York or to file it in Washington, D.C. And I told these folks, I said, I have to compare the laws and compare the opinions of the courts in both circuits before I can give you meaningful advice. Because it can make a big difference. Choice of your forum can make a big difference. Where do you choose to sue should be evaluated on a case-by-case basis. So summarizing what we have learned so far, you can always withdraw. Most cases you can always refile. Federal courts are circuit-based, and circuits can have different opinions about different things. For example, in Virginia, I love litigation in Virginia and DC both actually. Why? Because everything is electronic. Things have been simplified. I especially like the Eastern District of Virginia, which is Alexandria, about 5 minutes drive from here. It's called the Rocket Docket. It's the fastest court system in the country.
Rocket Docket.
It's called the Rocket Docket. They take no nonsense. The judges move cases along. You can't drag your feet. I like that because it's good for our clients.
Gotcha.
And the government lawyers also, I find actually both in DC and Virginia, I found them to be pretty reasonable. I understand there are one or two exceptions. I was an expert witness in a federal court case, and the prosecutor seemed to be very upset with me personally. He told me, he says to me, Mr. Khanna, I've read your articles, and that's not what you said in the article. And I said, sir, you are confusing compliance with consent. Just because I comply doesn't mean I agree with you. I comply because it's cheaper for me to comply than argue with you. And he didn't like my response, and he tried to badger me, and the judge smacked him down. Occasionally, you will run into people who are either unreasonable, and they may not be unreasonable. Maybe they feel such crusader-like zeal for their cause that they feel they're protecting the interests of the criminal system, that they want to knock down everybody who comes in the way. But most people are reasonable. When we have a genuine case and we are genuine with our opposite side counsel, that doesn't mean I'm going to make friends with them. It simply means I don't have to be enemies with them.
Gotcha.
We can disagree without being disagreeable.
Gotcha. So I believe every time you withdraw, you have a case that involves withdrawal or reappealing. The lawyer, it's important for lawyer to look at which circuit, or as you said, which city or state to look at.
Now, that brings me to the last point that I want to make in this context. USCIS considers itself to be a national body. So if you have a lawsuit decided in a district court, they consider themselves bound by the decision only in that case.
Okay.
But if another case comes out of DC, they can use the same set of bad rules that they did.
Right.
If the Court of Appeals decides, they are bound in that circuit by that Court of Appeals decision, but not outside that circuit. So you could have a different law in California and a different law in New York and a different law in Washington, D.C. I'm calling it law loosely, but a legal interpretation.
Okay.
So that's important to understand. In the beginning, I came from a litigation background. It was very difficult for me to understand, how can government do this?
Like have different rules.
From the process throughout the land, and some of that we have seen happen where judges will issue nationwide injunctions that, okay, I'm sitting in New York, but this applies all through the country, and they can. And there's some interesting legal issues associated with nationwide injunctions from district courts. But keep these things in mind.
Okay.
So when you sue, don't worry so much. It's going to cost you money, but most immigration lawyers who are litigating are reasonable. Most of these cases, we lose money because it involves more work. We give a flat fees. Okay, this is what we're going to charge you. You know exactly what you're going to pay. We end up losing money in 90% of these cases, but it's worth it because these cases need to be litigated. Laws need to be changed.
Gotcha. Great. Well, thank you for that additional piece of information, Rajiv ji. And as you were talking, I see there are some more questions that have come up. So I guess these are some last 4-5 questions. Let's address them. And then we can have the next session. We'll just inform about the next session to the same set of attendees. So this person is asking, can H4 directly search for a job where the company is ready to file H1B? And what are the changes of getting H1B?
Chances, she must mean chances of getting an H1.
Yeah, I guess. I'm sorry.
So yeah, searching a job is not job. Searching for a job is not a job itself, right? So you can search to your heart's content.
Right.
Search for a job, shake hands, go have, I don't know, strawberry ice cream sodas with them. That's not a problem.
Right.
Come to think of it, I would like a strawberry ice cream soda. So yes, absolutely. Looking for work is not work, no problem. What are the chances of getting an H1B? Well, that's like saying, what are the chances of me passing the exam? I don't know what is the exam. I don't know what is the level of your preparation. I don't know what questions will be asked. So generally, if you are qualified and the job requires those qualifications, why not? You should get an H1B.
Gotcha. Great. The next question is, I'm on my STEM OPT extension, which ends on June 25th of 2020. I'm willing to go to PhD. I guess the person is saying I'm willing to undertake a PhD. I'm planning my PhD in cybersecurity. Do I need to go back to India to get the visa to pursue PhD? What are the visa possibilities to pursue a PhD in this country?
Call the International Students Office of the school you want to go to. Most of the times, if you are still in student status, they can just roll your SEVIS, your admission, over to the higher degree. So you don't have to go outside USA. Contact the DSO of the transferee school.
Okay. And the same person is asking if I am eligible only for a full-time PhD or an online PhD as well.
Again, the DSO will be able to guide you. You can take a certain number of courses. This became a big issue. Varshaji, this is before your time. There was a huge problem with Tri-Valley University many years ago. And one of the issues that we agitated thoroughly with the government as well as with the Indian government was that the definitions of how many courses you could take online and still maintain your student status, those parameters were very fudgy. So government should not be allowed to fudge the laws and then impose them upon people as penalties. So it's like me saying, well, Varsha, the speed limit is about 35 miles an hour. But what does that mean? If I go 50, am I going to get penalized? I don't know. Maybe you will be. That's not how laws work. You got to give me the exact law. So the laws were very fudgy, but the government used them anyway. And I'm not sure that they have clarified them much more, but check with the DSO. Usually, if you take the DSO's advice and you can document it, that you took that advice, you should not have any major issues.
Okay. And what do you mean by documenting the suggestion?
Well,
like if
he said, she said, I said, she heard.
Okay.
If it's in an email or they give you something written that says, well, here's a pamphlet that we have written down, take a look at it, and this is the law.
Gotcha.
That's what I would like to see.
Okay, perfect. The next question.
Before I go any further,
Sure.
Guys, remember one thing. Remember how Trump was very upset about Comey taking notes? In law, there is something called contemporaneous notes, which means Varsha and I had a discussion. As soon as the discussion was over, I took notes of what she said, what I said, and I dated and timed it. That on March 12th at 1:48 p.m., this is what Varsha told me. Those notes can be considered to be evidence. So if you have a meeting with your DSO, he tells you something, come out and write that down, date it, time it, scan it, keep it, and that can be evidence. That's
Oh, wow.
documentation.
Okay, great. That's simple and easy, but I guess very helpful if you have it in cases where you need it.
That's true for almost anything you do. Under the
Yeah.
federal rules of evidence, and I think federal rules of evidence exist in various formats in all through different states. Even state laws loosely follow the same rules. If you have contemporaneous notes of a conversation, you can definitely try to reduce them as evidence.
Okay, great. Next question. Currently, I'm working on day one CPT, but my previous employer did not pay me for work for 4 months. They also promised H1, but of course, all this was false promises. They wasted my time and energy, and also I lost the time frame of applying for my H1. He or she lost the H1 window. It's been almost a year now. Can I apply for U visa on the basis of fraudulent employment?
I am not an expert in U visas.
Okay.
I am not sure what the outer limits of the U visa are, but what I can tell you is this. First of all, CPT does not require you to be paid. CPT, OPT first year, both of them don't require payment. You can have jobs that don't pay you anything. But STEM OPT extension requires you to be paid the prevailing wages. Let's leave that aside for a moment. Most states will recover your money for you. If you have worked for an employer and they haven't paid you, pick up the phone and contact the state employment agency. They are called different names in different places. In Virginia, they're called Virginia Employment Commission. In Maryland, I think they're called Maryland Department of Employment Services.
Okay.
So they're different. They're state level government employment agencies. Pick up the phone and call them. They will recover your money for you.
Great, but is there any expiration date to do this? Like, what if it's been more than a year?
I think there is a limitation. How long that is, I do not know. It depends upon the state law.
Gotcha.
But you can also, if the money is amount is large enough, you can also talk to a lawyer. In most states, contract and semi-contract amounts can be recovered for up to 5 years.
Okay, great. Next question. I do not have my old I-797. Can I visit India? And what are the consequences? The person actually wrote what are the worst consequences. But yeah, if you could just shed some light upon that.
It's another one of those questions, will I pass the exam? Now I don't know what the exam is. What was the 797 for?
Right.
Was that an H1B approval? Was that an I-140? 797 is simply notice of action. When the government decides any case, they send you an I-797. So what is that 797 relating to? Have you been maintaining status in the meantime? Impossible for me to comment.
Okay. Well, I hope the person is listening to this conversation, and as we address the next question, he or she can just specify what kind of I-797 was it. So you can also answer that question. The next one is, I have my I-140 approved, EB3. My company agrees that I qualify for EB1, but they are afraid to file it as EB1 because there are a lot of rejections there have been of late. Can I get my status changed from EB3 to EB1 by hiring a different attorney not associated with my company?
Your company is behaving like a hesitant boyfriend to be. They are afraid of rejection? Why is that a problem? I don't know. That doesn't sound right to me. Maybe you have half the information and maybe they have 1/3 the information they need. Why is rejection an issue? And most immigration lawyers who are experienced can take a look at the case and pretty much give you a prediction where it's going to go. Most of us have done thousands of cases. I remember when I first applied to be an expert. First I applied to be a class counsel in a class action lawsuit many, many years ago. I'd already done like 50,000, 60,000 cases by that time. Now I don't know what the numbers are. So most of us have done so many of these cases. We can look at a case and tell you where it's going to go and where the problems are. It doesn't mean we're going to be right all the time, but at least we can draw a roadmap which is more likely to be right than wrong. Can you get an outside counsel? Look, EB1 is an application. EB1C and EB1B are applications made by your employers. EB1A Extraordinary ability alien is your application. You can go wherever you want. You can get a lawyer, whichever way you want to go. But EB1B and EB1C, EB1C is executive and managerial employees, EB1B is outstanding professors and researchers. These are employers' applications. You cannot divorce your employer from the process. You can pay the fees, the lawyer's fee, but you cannot divorce the employer.
But is the fear because, if your EB1 is rejected, you are supposed to leave the country immediately?
No.
Are there some rules like that?
No.
There shouldn't be any fear of rejection in that case.
That's why I think that makes no sense. I can understand if I'm trying to propose to a lady and I'm afraid that if she says no, my heart will break into a million pieces and I'll end up singing sad songs. Other than that kind of fear, I don't see why you should be afraid of a rejection from the government. What do I care?
Okay, well, I guess the company then should just like stick with the right thing to do, and there shouldn't be any fear of rejection. I am just so this is the last question, Rajiv ji. Let's just take this as the last one, and I guess we can close this forum for today. The last one is this is coming from the same person who asked you this OPT CPT question before. As Rajiv ji mentioned, the day one CPT is a kind of illegal. Will that be safe to maintain the status to stay in the country while our H1 application process is going on?
As I told you, government thinks it's illegal.
Yeah.
I think not. But they are not likely to push it. It's your choice. It's certainly, if the government wanted to put you in deportation proceedings, they could. Would they win? I doubt it very much. Would they want to even push this issue because they know they have got this very shaky ground to stand on? I think they would not want to push it.
Okay, gotcha. I know I said that was the last question, but I see the user who had I797A question, just clarifying the information. It's H1B I797A. I am not getting from my previous employer due to contract issues.
Okay, so if you have the current H1B approval, the past H1B approval should not matter.
Gotcha. Great. So I guess this is it.
One more quick point.
Rajiv, go ahead.
If you don't have copies of your paperwork, file a Freedom of Information Act request. You can do it online. It doesn't cost you anything. And typically you can get a copy of your immigration file from the government.
Okay, great. And Rajiv ji, there are two more questions. I'm sorry, we have 3 more minutes.
I don't mind. I don't mind at all.
Great, thank you so much. I really appreciate it. So this question goes like, currently I'm working full time for an IT company on my OPT. Can I visit India? While returning, would there be any issues and what are the precautions I should take?
Well, OPT, they are likely to question if you're working, you should have evidence that you've been working all the way through, and you must have a visa stamp to return. Don't travel when you're close to filing an H1B. Check with your lawyers. There are certain periods during which you cannot travel. But overall, yeah, traveling is okay if you have a visa and you've been working all the way through.
Okay, great. And the last one is, how long can I stay in the US if I do not go for my H1 visa stamping to my home country?
Depends upon what your current status is.
Okay, I think this is the same person who was an H4.
As long as your timely filed H4 application is pending, or as long as you have an H4 and you had no prior breaks in your status. See, when an application is pending, a timely filed application is pending, you are in authorized period of stay. So there are 3 different levels of legality: authorized period of stay, full status, and unlawful presence. 4th is out of status. So these are different concepts. But if you have a timely filed H4 application, you can stay while the application is pending and until the time requested expires. So if you asked for stay till 2021, you cannot stay past 2021, but as long as the timely filed application is pending, you can continue staying as long as 2021.
Gotcha. Great. So I guess this is it for now, Rajiv ji. Thank you so much for taking time out for us and our HOMEIS members and answering these queries. And to all the listeners, thank you so much for joining in. We really hope we were able to help you through this session. We plan to host this every 2 weeks. The format may differ and we will keep you posted on that. And as Rajiv ji mentioned, if you have any more questions, you can reach out to him on help@immigration.com.
Guys, I can't promise I'll be able to answer all your questions on the mail, but if it's a simple yes and no, I have never had any problem spending a couple of seconds on your case. But if you send me 3 pages of information, I may not be able to help.
Or Rajiv, do you know what we can do? Like last time, we can at HOMEIS, we can gather these questions, and for our next session, we can address those queries.
What I think we should do, and of course, subject to whatever our listeners and participants want to do, community members want to do, it's always a good idea. And this is what we do. We also hold, I've been doing it for 25 years. Every 2 weeks, we have a community conference call on Thursday at 12:30, every other Thursday. And what we do is we let people post in our forums,
Okay.
forums.immigration.com. You post your questions there. And I will typically review the questions about an hour before the conference. And if I find, well, 4 questions relate to the same issue, I'll combine them. I'll merge them so we can deal with them together in one go. That way, people who are listening to the conference have consolidated pockets of information.
Gotcha. Sounds good. So I guess we'll see each other in 2 weeks' time, addressing some more questions, helping some more people. Thank you so much once again, Rajiv ji, and have a wonderful day ahead.
My pleasure, and thank you all for tuning in. I'll see you guys later.
Thank you.